Joining us, we interrupt your programming for breaking news out of Summit County, where a judge is about to sentence Kouri Richins. Richins was found guilty in March of aggravated murder, attempted aggravated murder, fraud, and forgery in the 2022 death of her husband, Kouri Richins. We're going to go ahead and listen in. Kouri Richins just finished her sentencing speech.
In addition, the court has considered each of the factors set forth in Utah Code 76-3-201 subsection 2B, and has prioritized those factors as required by section 201-2C. Having considered the gravity and circumstances of the offenses for which Ms. Richins has been convicted, the number of victims, and available information regarding the history, character, and rehabilitative needs of the defendant, the court hereby orders that the sentences on counts 2 through 5 shall run consecutively to each other and to the sentence imposed on count 1. Moreover, the court exercises its discretion and chooses to impose no fines related to any sentence in this case. The court addresses the 5 counts on which Ms. Richins was convicted in reverse order. Ms. Richins, based on your conviction on count 5, third-degree felony forgery, the court hereby sentences you to an indeterminate prison term not to exceed 5 years. Based on your conviction on count 4, second-degree felony insurance fraud, the court hereby sentences you to an indeterminate prison term of not less than 1 and not more than 15 years. Based on your conviction on count 3, second-degree felony insurance fraud, the court hereby sentences you to an indeterminate prison term of not less than 1 and not more than 15 years. Based on your conviction on count 2, first-degree felony attempted aggravated murder, the court hereby sentences you to an indeterminate prison term of not less than 5 years, and that may be for life. Which brings us to the final issue, the appropriate sentence for count 1. Under Utah Code 76-3-207.7, there are only 2 options. An indeterminate prison term of not less than 25 years, and that may be for life, or life in prison without parole. And the law requires that the court consider each option. Under a sentence of 25 to life, and considering the effect of the 4 consecutive sentences, the time that Ms. Richins has spent in custody, and the current practices of the Board of Pardons and Parole, Ms. Richins would likely serve approximately 30 years in the Utah State Prison before receiving her first parole hearing. By that time, she would be 66 years old. Under a sentence of life in prison without parole, Ms. Richins would be in prison for the rest of her natural life, unless the Board of Pardons and Parole determines by clear and convincing evidence at some future point that she is permanently incapable of being a threat to the safety of society, at which time the board would have the authority to release her. Under either scenario, Ms. Richins will be incapacitated, meaning structurally prevented from harming anyone outside the Utah State prison system for at least the next 3 decades, and perhaps much longer. But the potential impact on the survivors of the tragedy created by Kouri Richins, most importantly, Kouri Richins' 3 sons, is more difficult to predict. On one hand, if the court sentences Ms. Richins to life without parole, one or more of those young men may come to resent that the court eliminated any opportunity they might have in the future, decades into the future, to express an opinion as adults with substantial life experience about whether their mother should, for example, be allowed to die with dignity. On the other hand, if the court sentences Ms. Richins to 25 to life, one or more of those young men may spend the next 30 years questioning why the court failed to protect them from the prospect of the person who murdered their father being released from prison at some time in the distant future, perhaps when they have families and children of their own. The court's contemplation of how those young men may come to feel about today's decision some 30 years from now comes from a place of genuine concern for them and humility regarding the court's inability to predict the future. Sitting here today, it is simply not possible for anyone, not even those young men, to know how their view of this case may evolve over the next several decades. My hope is that every person affected by Eric Richins' death will, over time, find their way to a state of peace. As for today, the court's duty is to make a decision, a weighty, long-lasting decision based on those convicted unanimously and beyond a reasonable doubt of attempting to murder Eric Richins, her husband, and the father of their 3 children. And then, having failed in her first effort of spending the next 17 days not changing course, but doubling down, preparing to try again, and ultimately completing the act through the administration of poison. And for what? Money. All for pecuniary gain. A person convicted of committing that sequence of acts in that way and for that reason, and who causes the absolute tragedy that has befallen Eric Richins' sons and family. A person convicted of those things is simply too dangerous to ever be free. Accordingly, Ms. Richins, based on your conviction on count 1, first-degree felony aggravated murder, the court hereby sentences you to life without parole. You have the right to an appeal. You must file a notice of appeal within 30 days. You have the right to be represented by counsel on appeal.